This is the Court Leader's Advantage, a podcast series for court professionals and by court professionals. Brought to you by thecourtleader.net and in cooperation with NACO, the National Association for Court Management. In the middle of last month's episode, I asked the question, should recidivism be a trial court performance measure? All the panelists said no, but the reasons they gave are worth hearing. This topic is one we may want to look at again in the future. We've all heard the criticism that the criminal justice system has become a revolving door. Defendants are arrested and tried. Most are convicted and sentenced. Some are incarcerated, others are placed on probation. The recidivism rate for incarcerated defendants is nearly 50%. Almost 1 out of every 2 incarcerated defendants is rearrested. The recidivism rate for defendants on probation is not that much better. 43% of probationers are rearrested within 3 years. Traditionally, there are 4 main purposes for criminal justice sentencing: incapacitation, punishment, deterrence, and rehabilitation. Rehabilitation is a goal not easily measured, and yet it seems to be one of the standards by which the public gauges the success of the criminal justice system. In simplest terms, the purpose of rehabilitation is to ensure defendants stop committing new crimes and become productive citizens. Recidivism is therefore an accepted measure for success in rehabilitation. One of the reasons why it is difficult to measure this purpose lies in the system itself. The criminal justice system is made up of multiple components: police, courts, defense and prosecution, the sheriff and state prisons for the incarcerated, probation departments for other defendants. What is the degree of responsibility each of these components bears in rehabilitating defendants? Is rehabilitating defendants even a goal anymore? We're only going to scratch the surface in today's discussion. We'll want to delve into this topic even more in later episodes. I'm Pete Kiefer, and welcome to the Court Leader's Advantage podcast series. This month, we're looking at one of the basic purposes of criminal justice, and if we should use recidivism to measure that purpose. Here to discuss this issue are Rick Pierce, Judicial Programs Administrator for the Pennsylvania Administrative Office of the Courts; Cheryl Stone, Court Administrator for the Superior Court in Clark County, Washington; Greg Lambard, Trial Court Administrator for the Superior Court in Middlesex Vicinage, New Brunswick, New Jersey; Kent Pankey, Senior Planner, Judicial Services Department for the Supreme Court of Virginia; and Liz Rambo, Trial Court Administrator for the Circuit Court in Lane County, Oregon. Thank you all for joining today's podcast. The trial court performance standards, or court tools, are focused on timeliness, accuracy, and access to justice. Now, over the years, a number of groups have raised the issue of the justice system's revolving door. Most recently, the National Judicial Task Force to examine state court response to mental illness alluded to the need to stop the criminal justice system's revolving door with the mentally ill. Given this advocacy, shouldn't we add recidivism as a performance measure to the trial court performance standards? Kent?
My answer would be no, because the trial court performance standards are a broad, general level of performance measurements that apply to all cases, civil and criminal. Whereas when you're getting into recidivism, you're really talking about a subset. And there are standards and measures for recidivism in the context of, say, mental health dockets and drug court dockets. So that's a more appropriate context than in the higher level broad trial court performance standards.
Greg?
Largely agree, but there's also, first off, I agree it should not be in the trial court performance standards, because whether or not someone recidivates after they've been tried, convicted perhaps, and sentenced, I mean, we're putting so much emphasis on the sentence, but that the trial courts have no control over corrections, probation, or parole. Although the caveat, in about half the jurisdictions in this country, trial courts do control probation. Case in point, I was a chief probation officer at one point.
Mhm.
I do think that recidivism data should be collected. It should be published, not calling it trial courts, but certainly called system data, if you will, because it's just very useful at this point. And there's ways to cut it down to get some analysis of those with mental health issues, those with SUDs, people who are, MICAs, all over the place. But it is at this point very pertinent, and it also is something we need to know overall how we're doing. But I think the very same thing, we also make sure that people understand the various things that could affect recidivism, because so many people really have not dug into that research. They allow, for instance, they'll emphasize one element, say employment, which is important, but it's one of 8 relevant statistical things in that area, and so much of it is ignored, and it's actually more predictive. So it's kind of something that should be done, but it would be kind of like an addendum to the trial court statistics, in my view.
So recidivism should not be a trial court performance measure, but it should be collected as system data. Who would be in charge of collecting and managing the system data?
I guess I'm trying to say that whoever is, whoever collects trial court data should also perhaps be interested in doing this, just not publishing it as trial court performance. It could be criminal justice system performance, because that means it's the entire system. And it actually goes a little beyond that, because if you really try to work on recidivism, you're going to be digging deep into the community, and they're system partners, if you will, but they're certainly not members of the criminal justice system. But I do think, again, at this point, it's something that it's not really published as well. I'm sure it's published somewhere, but it's not, to my knowledge, it's not published nationally, not like some of the other stats that we're talking about.
Rick?
My concern, and my initial answer to your question would be no. That should not be part of the trial court performance standards. And for the reasons that Kent and Greg both stated, that although, yes, I think there are many factors that lead to the increase or decrease in recidivism, and that obviously the courts play a role in that. We should measure that. I'm not certain the individuals, maybe I'm being too skeptical and too critical and cynical of our people who would be receiving our data, mainly the general public, but I'm not certain they would really fully comprehend what it is that we're measuring, and that there are many factors and many departments, whatever, what have you, that have a role to play in this that does not necessarily reflect on the court. And so when Greg says, well, maybe it's the criminal justice system, I think that's a better classification or clarification for what we're looking for and measuring is, as opposed to naming it as the courts or the judicial system, because I think that is very misleading. But I do think that there should be obviously some measurements taken, and I think if it's shown internally at the very minimum, and then externally with a full explanation of who all are the partners that are involved in this process, then I think maybe we'll have an opportunity to fully explain our story.
Cheryl?
I just like to chime in as well. If the definition at a very simple level of recidivism is the tendency of a convicted individual to reoffend, there are so many factors that go into that situation that are outside of the court's controls. I think recidivism is a great measure for those types of problem solving or therapeutic courts where we are trying to drive a change in behavior. But the vast majority of criminal cases that come to our courts are not in our therapeutic courts. They're not in our problem solving courts. And oftentimes the state has provided sentencing guidelines that judges must follow. So to add recidivism as a trial court performance measure doesn't seem to make sense, but it may be a good measure for some the larger system as mentioned here. But we can't necessarily, in the majority of cases, influence somebody's individual decision to commit a crime.
I really wish that we could spend some time to educate people on just what it is that drives recidivism according to the research. It's something like 8 factors. That's it. Those are the ones they found. And some are more predictive than others. Normally the ones that talk about, connection to others who had the same kind of criminal thinking, criminogenic thinking, they call it. But it's so simplified in the public discourse and it's so misunderstood. We're back to that argument, Peter, where the good argument overwhelms statistics. And in this instance, this is just something that's begging for the public to understand this better, so they can stop worrying about judges who they feel are lenient, when really the case of the matter is sometimes that's exactly what is going to reduce recidivism and exactly what's going to make us safer. And it's counterintuitive, but you have to teach people, otherwise it doesn't work.
Sometimes it's even the prosecutorial policy in terms of jailing first-time offenders and other things where there has been studies about the impact of recidivism for new offenders into the system and spending time in jail.
Liz?
I'd like to add
Yes.
one more thing, if I may.
Sure.
I agree with everything everybody said, but I'd like to add this complexity. Recidivism is defined differently by everybody. For example, in Oregon alone, our treatment courts measure it as new offenses. Our DOC measures it at showing up in DOC again, Department of Corrections at the state pen. Our local police agencies measure it as contacts. So if we can't measure it as a system, even locally, like we know what we're talking about, then how are we going to do the thing that everybody's talking about here, which is make a reasonable and informed explanation to the public? And then also, I agree, it's not a measure of trial court performance. So thanks.
I want to hold on to this thread just a little bit longer. All of you have said that recidivism should not be a trial court performance measure, and I accept that. Setting that aside, do the courts bear some responsibility for the revolving door, arrest, adjudication, incarceration, release, and then rearrest? Cheryl?
Again, I think it's the context of that question. If we are running some sort of therapeutic court, then I think we need to look at the reality of that and determine if the services and the program is really meeting the objective. However, in therapeutic courts that I've been involved in, progress can mean no new arrest in a year. When I worked for the city of Eugene, we had somebody who had 79 offenses in 1 year, and then 1 offense the following year, by just providing the services and the support for that individual through a therapeutic court program. Can we run all of our dockets on a therapeutic court? No, we can't, and it wouldn't be appropriate to do so. Some people knowingly and willingly commit crimes without mental health or substance abuse involved. And so I don't think recidivism is a great measurement for the entirety of the court process.
Kent?
That's a tough one, Peter. Judges and other people in the courts certainly need to be aware of the consequences of their decisions and take some responsibility within the legal framework and the separation of powers. That's where it's difficult for judges sometimes to speak up to issues that are arguably part of the legislative function. They can certainly consider issues of leniency based upon, objective facts. They can make presentations to the judiciary through proper channels to suggest that the laws may need to be changed in certain areas, whether it be people with drug addiction finding different alternatives, not necessarily within a drug treatment docket, but just finding other alternatives for dealing with, mentally ill individuals and the like, that, finding treatment in the community is better than incarcerating them where they're just going to get worse and reoffend, which is part of what we're talking about.
Liz?
I would say that the court bears some responsibility every time we interact with an individual in a way that either can promote best practices to reduce recidivism or not. So, for example, Cheryl mentioned treatment courts. We have the ability to impact that. Also in pretrial release, we know there are best practices that create more criminal behavior and best practices that don't. So for courts that run pretrial release programs, we bear a responsibility to run those in such a way to help reduce crime in our communities. But there are places where the separation of powers, like Kent was talking about, it becomes fundamentally not our responsibility to deal with that, to remain neutral and to take the course that the case that's before the judge. And also, as others have mentioned, so much in Oregon is driven by sentencing guidelines that it becomes out of the judge's hands even at times to deal with some of those things. So I would say yes, every time when we have an opportunity.
Rick?
I agree to a large extent what Liz just stated. I think that the courts do have a responsibility, and it's a small one, and they play a role there because I think they're very influential at the general jurisdiction, the local level in the criminal justice system. Many of them participate in, it's named differently in other states. In Pennsylvania, we call them criminal justice advisory boards. And these advisory boards are wonderful forums for talking about processes and protocols and how we're going to go through certain types of cases, like these particular cases that you're referring to. And the court is a leader on these advisory boards. And your judge sits as a chair or co-chair. And I just think that if that's the case, then there is a role there to play, and with every role, there's a bit of a responsibility. I'm not saying it's the largest responsibility. It's kind of spread around among all our criminal justice partners, but I do think we do have a responsibility.
Greg?
Where the court has the ability to to sentence as more or less they please with maybe wider guidelines. Some guidelines are so tight, I would say the court has absolutely no chance at this, besides just providing a fair forum for dispute resolution. But where they do, when the court ignores the science on recidivism and how to deal with people change behavior in a positive way, I would say absolutely they're responsible. They have a responsibility, and it's actually ignored so often. It's horrible. The court should not over condition someone. I've seen some crazy orders. We had a judge who wanted to order a juvenile to read a novel and write some report about it. All right, I'm not sure I understand the scientific basis of that change of behavior. Certainly going to waste some time, but there's other things like that where they just, people who have not been trained in how to change behavior, been trained in other parts of the law and all that, sure. But at that point, unless you know what you're doing, unless it's backed by the science, I think you need to step back and let the people who have studied this, who've done this for a living, and are always trying to improve, let them take over and do the best they can to change the behavior of someone in a positive way. But when you ignore that, yeah, you're actually adding to recidivism. That's my personal view, and it's backed a bit by amount of research. So
there is something that Liz said that I just wanted to also that reminded me of something. The responsibility the court has that really can impact recidivism is the timely and swift resolution of cases. I think that's probably one of the largest areas that's supported by data. So courts should really be paying attention to their time to disposition numbers from that regard, because the sooner that you can resolve a case and still have it be, go through due process and be fair and neutral, have the right timing to it, then data would show that will reduce recidivism. I think it's also important, one of the things that Greg said is that, we need to make sure our judicial officers are informed and have information about how their interactions with an individual in the courtroom can impact recidivism, their sentencings, but also just their hearings and explaining their decisions and things like that can make a big difference.
I want to thank Rick Pierce, Cheryl Stone, Greg Lambard, Kent Pankey, and Liz Rambo for sharing with us their opinions on whether recidivism should become a trial court performance measure. This is truly a very interesting topic. As always, my thanks to you court professionals tuning in to today's episode. Your dedication to effective court administration is one of the foundations of our criminal justice system. Thank you for all you do. Join us on Tuesday, November 21st for another episode dealing with the issues facing our courts. This has been the Court Leaders Advantage podcast series. I'm Pete Kiefer, and thanks for joining us today. Thanks for joining us today. The Court Leaders Advantage is a regular podcast on courts and court administration. Today's episode will be available on our website, on YouTube, on Facebook, on iTunes, on LinkedIn, and on Twitter. Become part of the conversation. If you have questions, comments, or ideas for future episodes, email us. Our address is CLApodcast, that's all one word, @nacomnet.org. Did you hear an interesting comment by one of the panelists that you would like to listen to again, but you don't want to search through the entire episode to find it? The additional resources section of the webpage contains a question time marker sheet. Just find the discussion question on the sheet, and next to it is the time that question was asked. You can then quickly fast forward to that time in the episode and listen to the panelists' comments. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leader website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.